Welcome, everyone. My name's Lisa Brown. I'm the Executive Director of the American Constitution Society. It's great to see so many friends here. And ACS is really excited to be releasing today's study on how employment discrimination plaintiffs are faring in federal court. And we have an august panel to discuss and debate the findings of the study today. And I know we're all looking forward to a very robust exchange of ideas. And I just wanted, for those of you who aren't really familiar with ACS, programs like this are what ACS is doing all around the country right now. And we now have 165 student chapters, 30 lawyer chapters, 8 working groups on issues ranging from voting and democracy to separation of powers and federalism to access to justice, as well as a variety of print and electronic publications. And through press briefings like this, briefings on Capitol Hill, our publications and programs that we're hosting are in cities around the country, we are focusing public attention on key legal and policy issues that are shaping the face of our nation on a state and federal level. And that is exactly what this program today is all about. One of those issues, and we really do, it's a very broad array that we work on, but one of those issues is the state of our justice system. And as some of you already know, we host a number of programs on the Supreme Court, on judicial nominations, on key cases that are pending before the court. We have also been focusing attention on the politicization of the Department of Justice, on the new FBI guidelines for when they initiate investigations, for handling of state secrets in litigation, all sorts of aspects of is our justice system really operating fairly. And obviously that is at the core of today's study. Because of ACS and our belief in the Constitution, I often find myself sort of looking back at what our founders were thinking about. And to me, anyway, they understood the critical importance of a fair and impartial judiciary for a place where people could go for redress of grievances. And they believed in it so deeply, they made it one of the 3 branches of the 3 key pieces of the tripod of our tripartite system of checks and balances. And this study today really does raise fundamental questions about how that system is operating right now. And some of the questions are pretty troubling, and obviously we want to be thinking about them, talking about them, what should we be doing about them. And I hope that, in addition to discussing the findings of the study, part of the conversation will be about how we make our judicial system as fair as it possibly can be, because that's something that all of us need, and certainly that benefits our country. So it's great to see all of you here, and I want to now turn things over to Judy Applebaum, who is our Director of Programs.
Thank you, Lisa. As you heard, I'm Judy Applebaum, ACS Director of Programs, and I want to join Lisa in welcoming all of you and in thanking our wonderful panelists for being here today. And I'm just going to say a quick word about the reason that we're here, which, of course, is the new study by Cornell Law Professor Kevin Claremont and Cornell Law Dean Stuart Schwab. We're delighted to be able to do this, and I hope you all picked up a copy of the reprints that are outside. We have many of them. If you didn't get one on the way in, please get one on the way out. What I want to say is why we think it's important to bring attention to this study. What's significant about this study is that it's an opportunity to take a look at what the lower federal courts are doing on an important issue. Of course, some attention is paid to the Supreme Court, if sometimes sporadically and not always in great depth. But I think it's fair to say that very little public attention focuses on the federal district courts and courts of appeals, beyond the litigants in the cases and the lawyers who represent them. And this is a chance to focus on those courts, put them more on the radar screen, because after all, it's the lower courts that have the last word in the vast majority of cases in the federal system. Only a tiny percentage of cases make it all the way to the Supreme Court. And the rulings in the lower court cases have a tremendous impact on the lives of people, especially in an area like workplace fairness. Now with this study, we have a chance to learn from empirical research based on data that's maintained by the court system itself about patterns in lower court behavior that otherwise would most likely go unnoticed. And the findings are quite striking, as you'll hear. So we're delighted to be able to draw attention to the findings, to facilitate a discussion about their implications. And I should note that this isn't the only place that we'll be focusing on this study. We've learned that the Senate Judiciary Committee has scheduled a hearing for next Tuesday that will include a discussion of this study, and Cyrus Mary, in fact, is going to be testifying alongside Lily Ledbetter of the Ledbetter decision in the Supreme Court last year. So details, I think, are on the Judiciary Committee's website if you're interested in that. Now, to today's panel. We are delighted to have Dean Stuart Schwab, who will explain his study and highlight some of the findings. Cyrus Mary, who will give us the perspective of a litigator who handles cases from the plaintiff's side. Wade Henderson, who, as a leader of the nation's leading civil rights coalition, also brings his perspective from the debates over judicial nominations and judicial appointments. Eric Dryband, who served as general counsel in the EEOC during the Bush administration and now has a practice that includes representation on the defense side of employment cases. And moderating the discussion will be the Honorable Nathaniel Jones, whom it is now my great pleasure to introduce. Judge Jones served on the U.S. Court of Appeals for the Sixth Circuit from 1976 to 2002. He's now with Blank Rome in Cincinnati, where he represents a range of clients and also serves as the firm's Chief Diversity and Inclusion Officer. Judge Jones has received many, many honors and awards and even has a federal building named in his honor, the U.S. Courthouse in Youngstown, Ohio. I think it's probably a safe guess that no one else in this room can say that. He has taught at Harvard Law School, the University of Cincinnati Law School, Case Western School of Law, and elsewhere. He's a member of numerous civic and community organizations. His achievements are obviously far too numerous to catalog. So I'm going to stop here and just say that we are very, very honored to have you here, Judge Jones. And now I'll turn the proceedings over to you. Thank you.
Thank you very much, and good afternoon. It's indeed a pleasure to have been asked to moderate a panel of such distinguished and knowledgeable legal minds committed to the issue of constitutional justice and civil rights. I think this subject that we are about to hear from these very enlightened presenters is a subject that cries out for the kind of scrutiny and examination that is underway. And I think we're so fortunate to have persons who have committed themselves to this field. If I may just exercise the prerogative of a moderator chair for just a moment, as I just before I introduce the panel, I would observe that it was Justice Thurgood Marshall who, in a very famous speech on the occasion of the bicentennial of the Constitution, noted that our founding fathers didn't get it right in Philadelphia, and that it took a civil war, the Emancipation Proclamation, the Civil War, and 3 amendments to the Constitution before we really got on the right track. And in those amendments, the 13th, 14th, 15th Amendments, there's a provision that Congress may enforce and supplement the substantive guarantees in those 3 amendments by appropriate legislation. And that language in each of those amendments provides the basis for the various civil rights legislation and bills that have been enacted, and notably the 1964 Civil Rights Act with its Title VII. And as those, as the courts and litigators and groups grappled with ways of implementing and making real those promises that are contained in the law, the success generated pushbacks, and so we had a great deal of we saw a clash that was that drew that I think was somewhat stimulated by events of 1980 when during the campaign of 1980 there was a promise made that judges who would be appointed would be in that administration that came in 1980 would be judges who would bring about a sea change, that the administration would bring about a sea change in the makeup of the federal bench, so that we would have judges who would no longer be activist judges. And the term activist was a euphemism in my mind for something else. And that, I think, has led to a lot of what we have been struggling with, and these lawyers have been struggling with, and I think the picture that will be painted by this study, I think, will help explain what some of the results of that sea change have been. To carry us through this, I think we should take note of the expertise we have here at the head table. The study is a fantastic piece of work, and I want to salute the authors of it. I'm not sure of the order that we are to appear, that the various presentations will be made. I don't know whether the lineup is some indication of it or not.
I think it's
we'll start
with Dean Schwab and come across to Eric.
All right. The first presenter, well, without providing a sequence, I'll just tell you who we have. Eric Drebrand, who's a partner in the firm of Jones Day. He was former general counsel of the U.S. Equal Employment Opportunity Commission. He represents companies and counsel's clients. And I believe you have a handout with all of his bona fides. He has a remarkably broad and comprehensive range of experiences, which certainly prepares him to provide a considerable enlightenment for us. Some things jumped off of the page at me. Number one, Jones Day. Jones Day is a Cleveland-based firm. And in my new life, I've had the opportunity to co-counsel with some lawyers from Jones Day, and it's a first-rate law firm, and I think that for us to have the opportunity to hear from him will be a real honor, and I will not go further because we need to reserve that time for our presenters. The next person I will identify is my uncle, Wade Henderson. Wade Henderson is the go-to person. Those of us who have been in the struggle for a long time have always identified a key person to whom we go whenever we are faced with challenges and we need direction and motivation and inspiration. I came out of the tradition of when the go-to person was a Thurgood Marshall and a Clarence Mitchell, and Wade Henderson he stands in their stead. He is the personification of a Thurgood Marshall and a Clarence Mitchell and a Joe Rao, and all those persons who were present when we formulated the strategy and brought about the enactment of the key civil rights bills. I won't particularize Wade's accomplishments. They're too numerous that we'd be here all afternoon if I were to do that. But we're very lucky to have my uncle, Wade Henderson. And I must say that I am very much indebted to Wade because Wade serves a very special a role for me. I have a daughter in Washington who's very much involved in a number of things, and she takes comfort in knowing that even though in my absence, I'm not here, she can always turn to Uncle Wade for reinforcement, for guidance. So that's the nature of our relationship, and we just have enormous respect for the leadership that Wade provides, and I'm sure his presentation today will be very edifying to us. And then there's my co-counsel, Cyrus Mary. He and I have worked together on some cases, and I've just marveled at the breadth of his knowledge and the depth of his commitment. The first time I was dealing with, had some involvement with Cyrus, I was on the side of I was on the other side, and the lawyers and the clients were afraid of you. And I went, who is this guy, Cyrus Mary? Everyone talks about Cyrus Mary. He'll do this, and they were wargaming you. And then I met you, and I said, gee whiz, he doesn't have horns. He's a he's a very bright, sensible, reasonable, practical person, but he's committed, and likes to work things out, and likes to see change come about. And that led to Cyrus and I teaming up and working together on some matters, and then I learned, of course, in the process that he clerked for a very dear friend of mine, a dear colleague of mine, Judge Nixon of the District Court in Tennessee, and I just think that the civil rights community is very lucky to be able to call upon and rely upon a person with the commitment of Cyrus Mary to move this litigation forward and to bring to fruition the objectives that the drafters of the civil rights bills had in mind. And so we'll be hearing from Cyrus. And last but not least, we will hear from Stuart Schwab. You will, no doubt, if you haven't, learn more about the study. It's some good reading. It's very good reading, and as one who served on a court of appeals, I find it helps explain a lot of things, and it's right on. And if when he and I are able to sit down and have a beer, I will give him some chapters and pages and verses that will reinforce what he has already concluded from his findings. I think this is a profoundly important and significant piece of work, and I think we can learn a great deal from it, and I hope in the coming years we can benefit from it and see to it that the promises that are a part of our civil rights jurisprudence will become a reality for more people. So those are the persons we'll hear from this afternoon, and with that I will take my leave and sit over here in my corner, and maybe toward the end I might interject a thought or two, but we will begin with our first presenter.
Well, thank you so much, Judge Jones, and I look forward to that beer that we're going to have. And I'm really pleased and honored to be able to speak with such a great panel and all you coming. The only thing I want to say of all the great training, if I can use my dean's hat for just 1 minute, I must highlight the special training of one of our panelists, and that is Cyrus Mary has this. I must say the best training of all. An alumnus of Cornell Law School. But I'm going to take off my dean's hat now, in deference to the other very distinguished panelists and those in the audience, and I put on my scholar's hat. I'm very pleased to have the chance to present this today. I've done it in a PowerPoint form here because it's an empirical study. It's the data, and if I just start speaking a bunch of numbers, I think it can just not be there. So I've prepared 10 slides that I hope will distill the essence or core findings of the report. So let me just get to them. First, our methodology. This study uses the official data from the U.S. courts, gathered by the Office of the U.S. Courts. The clerk in every federal courthouse at the end of every case is required to submit a form that just, what was this case about, what kind of case was it, who won, those sort of things, and that's submitted, compiled by the Federal Judicial Center, and then disseminated to scholars, and it is the official record of the business of the U.S. courts, and it is every single case. 1979 to 2007. The key category that we are examining is just category 442, which is one of the some 100 or so categories. Civil rights jobs is what it is, and it is the employment discrimination cases in the federal courts. About 2/3 of them are the Title VII cases, Title VII of the Civil Rights Act of 1964, which is the basic federal statute that prohibits discrimination on the basis of race, sex, gender, color, and national origin in employment. It also does contain Disability Age Act, Family and Medical Leave Act cases, and other cases, and that rounds out the discrimination cases. And so our basic strategy is just to compare those cases, the 442 cases, and in their numbers and how they're doing to other cases in the federal courts. I should say civil cases. We are leaving out the criminal side, which of course is a very important part of the caseload, but we're confining this study to civil cases. We did a first article some 4 or 5 years ago in the Journal of Legal Studies where we used the same analysis on this finding. And today we're presenting from the current article forthcoming in the Harvard Law and Policy Review, and I hope you have had the chance to sort of get the it's actually a preprint. The official article is going to be coming out shortly, but our work is largely done. And I just want to highlight so that this data goes through 2007 in some aspects, but the core data set that we were able to get from the U.S. courts through the Federal Judicial Center, through the consortium of universities, goes through 2005. It's the latest available data from this data set. Okay. And I'm just going to focus on 3 areas for my presentation. The number of cases, number of employment discrimination cases over time, the success rate in the trial courts, in the district courts, and then the success rates on appeal. Core findings. There's been a startling drop in the number of employment discrimination cases in the federal courts this decade. An absolute drop of 21% through 2005, and then an even larger drop in the succeeding 2 years, so that between 99 and fiscal 2007, a 37% drop in the number of cases terminated in the federal courts. At the beginning of this decade, century, millennium, 1998 or so, employment discrimination cases were the largest single category of cases on the federal docket at nearly 10% of the entire civil caseload. And that's really dropped remarkably in this decade to go down to under 6%. And that's really quite a large drop in just 9 or 10 years. The win rates at trial court are low for these employment discrimination cases. If a case gets to trial, of course, the vast bulk of cases do not go to trial. They're decided on pretrial motions or settled. But when they go to trial, the plaintiffs, the workers in these cases, will win at 29%. There's 2 types of trials, as you know, jury trials, which are actually increasingly common among these cases, but then also judge or bench trials where the judge finds the facts as well as the law. And in those cases, the judge trials, the win rate is even lower, only 20%. Then our third core finding is what happens on appeal. When the worker wins a trial, the judge or jury says, yes, you have won, there is discrimination, and that case goes on to appeal and is decided by the appellate court. 41% of those cases are reversed. So it's sort of getting close to a coin flip on whether you'll be able to hold that judgment or not. By contrast, when the employer wins at trial, the judge or jury says, no, there's no discrimination here, and the plaintiffs appeal that up to the Court of Appeals, and the Court of Appeals decides, 8.7% reversal rate. This gap between 41% and 8.1% is the largest gap of any of the case categories in the federal courts. Employment discrimination cases have a larger gap. I'll come back to this a little bit. But these are my core findings. What I propose to do now is to throw up some of the actual numbers that come from the displays in the table. And here's the first sort of core one. This is the number of cases from 1979 through 2006. The red is employment discrimination cases, and I think that's blue are all other cases. That has no political meaning that I'm aware of, but I'm sure you can imagine one, but none was intended. There was a dramatic rise in cases in the 1980s. This was the litigation explosion that was not really employment discrimination based, but this is sort of all the other cases, because the real dramatic rise in the number of employment discrimination cases occurred later. Not in the early 1980s, they rose a little bit, not in the late 1980s when they rose not at all, but starting in 1991, this really jumps up to nearly almost 10% of the federal caseload. For those of you trying to look at this in the back, the scale on the two sides is different. It's actually a 10-to-1 scale. So it's not as if there are as many employment discrimination cases at the peak as other cases, but it's sort of a 10-to-1 ratio. But my story, our story, today's story from the top is sort of from here on, where this very dramatic rise in the number of employment discrimination cases in the 1990s is now dramatically falling. This chart goes through 2005. As I said, our entire database is 2005. If you add on the number of terminations the last 2 years, it actually drops off quite a bit more, and that's where we get this 37% decline. So that is the big story coming from display 5 in our article. A bonus for those of you at the presentation. Display 5A is not in our article. We do have a footnote about this. This is breaking this down by federal circuit throughout the country. What is the percentage decline? The number of cases in 1998 in each circuit, the number of cases in 2005 by each circuit, the percentage decline, and then we've ranked them, not literally by the percentage decline because that just has these endpoints, but using all 10 data points is our ranking. You'll see, actually, for those of us in D.C., D.C. is not where the action is. I think because of its low population. Excuse me for the inside the. Judge Jones will appreciate that something out of the Sixth Circuit is actually we should pay more attention to. I know this is hard to see in the back. D.C. had 360 cases, employment discrimination cases, terminated in 1998 and 357 in 2005. If that were nationwide, I wouldn't be up here today saying too much. But overall, we have had through 2005 this 21% decline. As I did report earlier, the succeeding 2 years after this, even more dramatic declines for 37%. What are the highlighted circuits up here? The biggest decline is in the 11th Circuit. That's Atlanta. That's based in Atlanta. That's the southeast of the United States, Florida, Georgia, Alabama. The 5th Circuit, the 11th, as many of you know, split off from the 5th Circuit about 20-some years ago. The 5th Circuit's the other, or the Deep South Circuit, based in New Orleans and also including Mississippi and Texas. And the 4th Circuit, right across the river here, based in Richmond and including the 2 Carolinas, the 2 Virginias, and Maryland. These are essentially the southern circuits where we are seeing the most dramatic decline. But it's largely a nationwide phenomenon, but most profound in the South. I also want to throw up this bonus statistic, which is a footnote in our article, because I think immediately one might say, as an explanation for the sharp decline in the number of cases, sharp decline in discrimination out there. That would be a very nice explanation. One bit of counter evidence is the number of EEOC charges, the number of complaints that the Equal Employment Opportunity Commission gets. And that's held really quite steady over this entire period, 1992 to 2007. Interestingly, quite steady even during the dramatic rise and quite steady during the dramatic fall. But it's, I interpret this as that as far as, people upset enough to file that charge of discrimination, that's held steady. I now want to turn, so that's the core on just the number of cases, which has shown this dramatic decline. I now want to turn to win rates. This is my most confusing display as far as, a lot of numbers wiggling with you. So let me just go through it briefly with you and then summarize it in the next chart. The red, again, are employment discrimination trials now. And I've broken it down into jury trials and judge trials. And then I compare it to other jury trials and other judge trials. And what is this? This is the win rate. What fraction of all these trials do the plaintiffs win? And I think you can see the outlier. Well, both these red numbers are under the blue numbers. So both in jury and judge trials in employment discrimination cases, they win less often at trial than in other federal civil cases. And the real outlier, interesting, is this bench trial. Now, it did have a little blip up here, but then a little blip down here, and certainly the overall is quite a dramatic difference. And interestingly, in other civil litigation, plaintiffs actually win more in a bench trial than a jury trial. You actually win. Plaintiffs do better before a judge than a jury in other cases, but not so in employment discrimination cases. Juries, judges. Judges, juries. See, so not only is it lower overall, but it's actually flip-flopped, that you really do, an employment discrimination plaintiff really does badly before a judge at trial in comparison to a jury, employment discrimination case jury, which does worse than an other jury, which does worse than an other judge at trial. Hopefully you're getting that, but just to summarize the overall points, we actually add pretrial. We discussed in the paper a lot of what's going on pretrial. I won't comment on that here. But now this is the combined trial rate. Jobs, you win about 28% of the time. Other cases, about 45% of the time. And then here's the real point. Judge trials in employment discrimination cases, you win less than 19% of the time versus in other cases about 45% of the time. So that's really quite a dramatic gap at trial. I now want to turn to my last point, which is what's happening on appeal. And I've already said the number, but let me just repeat it. 41.1, 8.7. When the plaintiffs win their trials and that case is appealed, it will be reversed 41% of the time. Versus if an employer wins the trial and the worker appeals, that'll be reversed 8.7%. Now, this anti-plaintiff effect actually occurs in all cases. Plaintiffs in other cases will get their trial victories reversed 35% of the time versus 14.7%. So in part, it's a general effect that plaintiffs have a harder time holding their judgments on appeal than defendants do. But it's much more pronounced in employment discrimination cases. Again, this is the largest gap. The things comparable to it are other civil rights cases. So let me just do my last slide, which is explaining to the degree we can, these core findings. And I'll do this quickly. Why the huge drop in cases, 37% in the 8 years? Well, I've already said the EOC charges remain constant, so I don't think just less discrimination is the explanation. Our explanation, plaintiffs are now recognizing what a tough row it is in federal court. Many of these cases we're guessing are going into state courts or being treated in arbitration or in other ways. There's not good data, comprehensive data on the state court systems over 50 states, and there's not comprehensive data on ADR either. So that has to be a guess on our part of where these cases are going. Why the low win rate at trial, especially the judge trial? And again, I've highlighted here what's happening at trial. It's consistent with what's happening at pretrial. It's every stage employment discrimination cases do worse. And our explanation is similar to, well, judges are just demanding more of the jobs or employment discrimination plaintiffs than juries do, and then they do in other cases. And then the double standard on appeal. We cannot find evidence that that once a case gets to trial, the plaintiff's cases are particularly weak. But our tentative explanation that the appellate judges are perceiving the judges and juries below as being pro-plaintiff, and hence scrutinizing those victories more harshly, while assuming that if an employer gets through a jury or a judge, that there's less need for scrutiny at the appellate level. So it's sort of an attitudinal explanation. That's the core of the report. I now look forward to the discussion by the commentators. Thank you.
Well, it's great to be here today. Just to put my Cornell Law alum hat on for a second, Stuart, we were blessed when I was a student that he joined the faculty after clerking for Sandra Day O'Connor. And then we were blessed when he became dean, and under his deanship, Cornell's really flourished as kind of the epicenter of journal empirical studies, which I just point to. This is just one example, and if you want to see a lot of good, great scholarship on the civil and criminal justice system, look at their journal on empirical legal studies and all the great work they're doing there. As a practitioner, there's two parts of the data that really just resonate with me that cause serious concern. One is the double standard on appeal. The idea that when an employer wins at trial, that they are reversed 8% of the time, which shows some deference to the fact finder. But in stark contrast, the employee victory at trial is reversed an astonishing 41% of the time. That causes me deep concern about our judicial system, that there's a double standard on appeal. And what Professor Claremont and Dean Schwab, one of their sentences in their report says, or the article says, that the anti-plaintiff effect on appeal raises a specter that appellate courts have a double standard for employment discrimination cases, harshly scrutinizing employees' victories below while gazing benignly at employers' victories. And what I want to do today is give some examples of how that comes to life, or bring to life some of these statistics. First, to provide some context. The employee's journey in the federal court system is a long and hard journey. First, they suffer through discrimination in the workplace, sometimes even a hostile work environment, but many times subtle but real discrimination, barriers to advancement. And a lot of times they don't even believe the discrimination to themselves until they're there for a very long period of time. But and many times they work within the companies to try to change these companies, try to work with them only to be rebuffed. And I found after interviewing literally hundreds of employees that they're very loyal to their companies. And they really, only as a last resort do they seek counsel. And when they go down that path, it's not always a happy journey. First, it's very hard to find counsel. No, the employees don't have the resources to pay for counsel, and so the cases are on contingency. So only the very best cases are selected by counsel because of the contingency aspect of it. So there's a serious amount of vetting. Even meritorious cases don't make it through the vetting process often. And so there's that first gatekeeper, which is counsel. Then the second step, after going through the EOC, is to go into court. And there they face daunting odds. They have great law firms like Jones Day on the other side who have great resources, who take their depositions, go through their documents, and it becomes a very consuming process for the employee. And often reliving the experience of discrimination in the depositions or in trial is just as harmful and painful as the first time around in the workplace. So it's not at all an easy process. And they have to overcome the motion practice. They have to show circumstantial evidence often that highlights the subtle discrimination. They have to convince the court that there's enough of a factual issues in dispute to deserve to go to trial. And as the Professor Schwab and Claremont will point out, that many, many cases, a large percentage of cases, are dismissed before ever going to trial on summary judgment. So the ones that make it to trial have already gone through significant hurdles to get to trial. And then to go to trial and to lose, and the fact that the employers win the majority of these cases by a large measure, somewhere around 75% of the time, means that those employees who have overcome yet those hurdles and convinced the fact finder, these are serious cases with able counsel by the time they've won that trial victory. And the idea that they could be reversed 41% of the time, and in sharp contrast to the 8% for employers, has not only debilitating impact on the workers and the employees, it has a demoralizing impact on counsel and the ability for people to practice civil rights law, and I think it imperils the credibility of our civil justice system when it's that stark a contrast. If it was a 2-to-1 disparity, I would say, well, that's troubling, but there might be some explanatory factors. There might be factors such as resource differences. But when it's 3, 4, 5-to-1 disparity, there's something deeper going on here. As Judge Jones said, it deserves serious scrutiny. And so there are real lives that are being affected by this. One of the most controversial cases of the Supreme Court in recent years is Lilly Ledbetter. And as Judy Applebaum mentioned, she's going to be testifying at the U.S. Senate again on Tuesday next week. Well, what happened to her really illustrates this kind of disparity. She worked at Goodyear Tire. She had sexual harassment issues at the beginning, but she hung in there and said this is where she's going to work, a very loyal employee. Immediately, she's paid less than her male counterparts. And that pay disparity continued year in and year out, so it had a cumulative effect. So at the closest to her male counterparts, she was 15% below their pay. And to some of her male counterparts, she was 40% below their pay. But she went through the process, got to a jury trial, and after careful consideration, they found her back pay was over $200,000, the shortfall of her compensation over her career. That is a tremendous victory and a heroic effort of Ms. Ledbetter. But that isn't where her case ended. Before she knows it, she's up in front of the 11th Circuit. And what do? Is they come up with a technical position on statute of limitations, one that is completely out of step with virtually every circuit court in America, and says, oh, guess what? You know, that original decision that puts you at that huge disadvantage, that happened years ago. And even though that every single one of your paychecks reflects that disparity, and you've been getting that up to the current time you have that disparity, guess what? You're out of luck because that decision took place long ago. Then she's up to the Supreme Court. And there you really see a distinction of how these justices look at it. And there, that decision was made, and I won't comment on it much more because our focus is on the appellate courts, other than to say that if there are justices and judges in America who think that workers know what their counterparts are making, they haven't had a job in America because it just doesn't exist that way. And so that failure to really understand the American workplace, I think, it was a factor that happened in the Ledbetter decision. But that's just one of many examples. We surveyed NELA lawyers around the country asked for input, and we just got a flood of really anguished emails about cases where there were hard-fought victories at trial reversed. One is involved Anthony Ashe and John Hithan, both African Americans who worked at Tyson's Foods, who were both superintendents. They were seeking promotions. Well, they were living in an environment there where not only were their promotions denied, but they were repeatedly subjected to racial comments by their supervisor, who called them boy on a routine basis. He'd call them boy, and to the point that Mr. Ashe's wife came into the workplace, told Mr. Hatley that my husband is a man, not a boy, and he still just laughed at her face in that case and continued that conduct. So the jury in this case looked at the evidence and found that the plaintiffs were deserving of the promotions, looked at the evidence and found that these were racially motivated comments. Yet the district court judge set aside the verdict and said that using words like boy could never be considered evidence of discriminatory intent. And it went up on the appellate court, and the 11th Circuit said that, when you look at disparities and qualifications and so forth, the evidence has to virtually jump off the page and slap you in the face. Now, that's a different legal standard than we learned at Cornell Law or any other law school in America, where it's all about circumstantial evidence, and it's all about subtle discrimination. And that became the standard in the 11th Circuit, and ultimately even this Supreme Court was shocked by that kind of standard and sent it back down. But as far as we can tell, the 11th Circuit is still holding firm on reversing this hard-fought trial victory. And a third example, and the last one I'll talk about, is a woman named Susan Septimus who worked at the University of Houston. I know there's some academic institutions that can be defendants, Stuart. But anyway, she was a lawyer. She was working as worked in the general counsel's office there, and she was seeking a promotion. But her supervisor really just said, by seeking this promotion, you came across to him as reminded him of a needy former girlfriend. And he got so mad at her for, trying to seek a promotion that he actually wrote a memo about his plans to retaliate against her when she filed a grievance. And then that led to an investigation by an independent counsel, an outside defense-oriented firm, who came back with a report that said she was discriminated against, and she was retaliated against, and she was in a hostile work environment. And the university chancellor just said, well, I know more than this outside counsel, so overruled that report. Well, ultimately, she had to move to a different department, found it very difficult for her to stay in her job, and she had to leave. She went to trial, and the jury, after considering all the evidence, awarded her over $300,000. The newspaper went and interviewed people and interviewed the jurors who had very harsh words for the university, and they felt like the university should have stepped in earlier to stop this conduct. So this then goes up to the Fifth Circuit. Hard-fought jury victory, defied all the odds to get there. And the Fifth Circuit, in their wisdom, said, you know what? The jury instructions weren't quite right. They said, you know what? And they pointed out what they thought was a flaw in the jury instructions in an area that the defendant never even objected to. The defendant never raised an objection on the jury instructions at trial. And I promise you that if a plaintiff failed to make that objection of a jury instruction, they would not be given a pass by the Court of Appeals. But this Court of Appeals gave the defendant a pass on failing to make the objection and said that the standard for retaliation should be a but-for standard instead of a motivating factor standard, a distinction that most scholars find one that's not, or at least a distinction that's often considered very confusing at best. But the bottom line is these plaintiffs worked hard, fought overcame extraordinary odds, had these trial victories, and for grounds that are really hard to understand, the Court of Appeals set aside the jury verdict, which I think is actually a slap in the face to American workers and American citizens who serve on these juries. So I'll just turn it over now to Wade, who will really talk about judicial nominations and all these other good things.
Well, thanks, Cyrus. Good afternoon, everyone. I'm very honored to be here. I want to thank Judge Jones for that overly generous introduction. I want to thank the American Constitution Society for the honor to be here this afternoon. In addition to my work with the Leadership Conference as president of that most esteemed organization, I have the privilege to serve as the Joseph L. Rao Professor of Public Interest Law at the University of the District of Columbia, the David A. Clark School of Law. And so I'm most familiar with the important work of ACS, and I'm always honored to participate in programs that enlighten and educate and present the facts as the American public needs to review them. So this is no exception. I think it's probably well chosen that I follow my friend and colleague Cyrus Mary, because I think the startling data that is really presented by the Schwab-Claremont study and the examples that Cyrus helped to lay out, which really shows how the courts are actually looking at these cases, confirms what those of us who follow the courts already knew. The federal courts have become more hostile to employment discrimination suits and workers' rights claims in general since President George W. Bush began appointing judges. Now, it has long been clear that judicial nominees have been selected by this administration. And again, I'm not speaking in every instance, and I'm sure that there are exceptions that individuals would point to. But I'm talking about the aggregate of a review of those appointments. They've been selected by the administration based on whether they, in many instances, are likely to advance the administration's ideological agenda. And although the media often seizes upon the social issues, the significant effect, really, of the Bush judges has been to advance a pro-business agenda at the expense of American workers. Now, there are many disturbing facts contained within the data. For example, the continuing low rate of success for employment plaintiffs in both trial and pretrial dispositions relative to plaintiffs in other cases, and the fact that the courts of appeals were more inclined to uphold judgments against plaintiffs in employment cases. But perhaps most disturbing is the growing reputation of the federal courts as hostile to employment claims. Private lawsuits are the primary mechanism by which our anti-discrimination laws are vindicated. And I worry that employers will grow less vigilant about workplace discrimination, knowing that their employees are chilled from even initiating a lawsuit against them. Now, the anti-worker trend extends to labor cases as well. An AFL-CIO study shows that the National Labor Relations Board cases, 30% of pro-worker decisions by the agency were overturned by the courts of appeals between 2000 and 2008. This despite the deference to which agency rulings are entitled, and despite the fact that the NLRB itself has become hostile to workers under this administration. The disfavor the courts now show toward workers' rights suits coincides with the Bush administration's successful pursuit of a pro-business agenda in its judicial selections. At present, 302 of 820, that is over 1/3 of the judges on our federal courts, are Bush appointees. On some of the circuit courts, the proportion of Bush appointees is especially striking. On the Eighth Circuit, for example, 7 of 11 judges were appointed by President Bush. It is no surprise, then, that according to the results of the study, employment plaintiffs are now simply avoiding the Eighth Circuit. One example of the President's brazen pursuit of an agenda for the courts is his recess appointment of Charles Pickering to the Fifth Circuit Court of Appeals. Now, Pickering had been filibustered because of his record on discrimination cases as a district court judge. Pickering reflects an attitude toward employment cases that might explain some of the data from this study. When asked why he repeatedly ruled against employment plaintiffs while a district court judge, Pickering argued that the EEOC usually resolves meritorious claims, and therefore cases arriving through private suits lack merit, a patently untrue assertion since the EEOC does not take action on the vast majority of charges it receives, including many charges that might have merit. Now, as more and more Bush nominees were confirmed, we witnessed many examples of the ways in which plaintiffs in employment suits lost out. Now, some instances are quite well known, and Cyrus has already delved extensively into the decision of Ledbetter versus Goodyear Tire and Rubber. But there, the Supreme Court actually made it all but impossible to remedy a pay discrimination case by using a statutory interpretation which, as Cyrus said, literally took the statute and turned it on its head. And again, this in part was because of an anti-worker decision in the 11th Circuit that caused a circuit split and thus gave the Supreme Court the ability to take up the case. But a far more insidious and commonplace tool judges use to throw out employment cases is summary judgment. By granting summary judgment, judges declare that the facts are so clear-cut against the plaintiff that there's no point in sending the matter to a jury. But in many of these cases, there are facts in dispute, yet judges impose their own views on the matter instead of letting a jury decide. Now, in the Bush-dominated Eighth Circuit shows the overuse of summary judgments. In 2006, the senior judge, Donald Lay, who passed away last year, took the unusual step of calling out his colleagues on overuse of summary judgment. In a dissenting opinion, he wrote, and I quote, "Too many courts in this circuit, both district and appellate, are utilizing summary judgment where issues of fact remain," unquote. Now, when a respected judge criticizes his colleagues for the way they decide cases, we know that there is something deeply wrong. The data from this study provides additional, strong, quantitative proof that something is indeed deeply wrong. I hope that by ensuring our judges are committed to fair play in workers' rights cases, we might help to reverse this deeply troubling trend. Thanks very much. I appreciate it.
Well, thank you. Let me say as an initial matter that it really is a privilege for me to be on the panel with Wade Henderson, Cyrus Mary, Dean Schwab, and, of course, Judge Jones. And I thank the American Constitution Society for inviting me to join this esteemed panel. I take a slightly different perspective, I think, than some of those we've heard because, as Judge Jones mentioned, I did serve effectively on the plaintiff side, not literally, but when I served as general counsel of the Equal Employment Opportunity Commission, and I've also served, as I do now, primarily representing employers. And so my perspective is shaped both by being, in effect, a prosecutor on behalf of victims of unlawful discrimination and seeking relief for them, and also in representing defendants as well. I think, let me start as an initial matter with what Dean Schwab discussed as the drop in the number of employment discrimination cases filed in the federal courts. And there are several reasons for that. Obviously, the data speaks for itself, but I think there are several reasons that I think may be driving that we haven't discussed today. First is the rise in what's known as wage and hour litigation. This tends to be claims by employees, by workers, that their employer has not paid them properly, that their employer has violated a federal law called the Fair Labor Standards Act, and that typically in those cases, and I'm sure Cyrus has litigated many of them, the claim is that the employer has denied overtime wages to employees or a class or group of employees. And the Fair Labor Standards Act, that was enacted in 1938, was largely confined to very small cases and in many ways neglected, I think, by the plaintiffs' bar until the last 10 to 15 years. And what we've seen is that as the number of discrimination cases filed has declined, that the plaintiffs' lawyers, as a general matter, have shifted focus somewhat and have filed a huge number of wage and hour cases against employers. I'll let Cyrus speak to that when he next speaks about why that is, but it certainly is something that I think we've seen a shift in emphasis from the plaintiffs' bar. At the government, at the Equal Employment Opportunity Commission, at the same time, we've seen an enormous expansion in the Commission's efforts to resolve discrimination claims during the administrative process short of litigation. And so as Dean Schwab noted, that there has been this decline from 1999 to the present in number of discrimination cases filed in the federal courts. At the same time, since 1999 through the present, there has been this huge expansion of mediation at the EEOC, that is where the Commission will invite both a person who files a charge of discrimination and the respondent, usually an employer or a union, to mediate the charge, to come to some resolution early on before either side has to go through the cost and agony of years of litigation in the federal courts. And so, for example, from 1999 through 2007, the EEOC conducted 98,000 mediations of charges that were filed, and 68,000 of those were resolved successfully. Last year also, and I will say I agree entirely with everyone's comments, including Dean Schwab's, there is no question that discrimination, employment discrimination, persists in the United States. And I think as evidence of that, I would note that last year the EEOC recovered more than $290 million in monetary benefits without litigation, and that was the highest amount recovered over the past decade. At the same time, starting in 1991, in a parallel track, we've seen a series of decisions by the Supreme Court of the United States in which the Court has said that employers may and employees may agree to arbitrate employment discrimination claims. This is part of this series of decisions that date back to a decision in 1991. And before that date, I think the general view was that employment discrimination claims could not be subject to mandatory arbitration. That is, there was the notion that an employer could condition employment on an agreement to arbitrate any future claims. And so what we've seen from 1991 to the present is that many employers, and this very often is industry specific, but many employers have required their employees to agree as a condition of employment that if they have a dispute with the employer, including a discrimination claim, that they have to arbitrate the case. That is, they cannot go to federal court, and they agree that the matter will be resolved by an arbitrator, and the Supreme Court has repeatedly said that is entirely lawful and, in fact, consistent with the federal policy embodied in the Federal Arbitration Act that favors arbitration of disputes. We've also seen, and Dean Schwab and I, and Cyrus and I, or Dean Schwab and I were talking about this, is that when we saw, as you'll note in Dean Schwab's chart, there was a spike or an increase after 1991 in the number of cases filed in the federal courts. That came I think as a result of the 1991 Civil Rights Act, which for the first time entitled victims of unlawful discrimination to recover compensatory and punitive damages and to have a right to a jury trial. At the same time, however, as part of a compromise that was embodied in that law, Congress put in a $300,000 cap on compensatory and punitive damages. And so I think what's happened after the initial wave in the federal courts is that many claims are being filed in the state courts before state administrative agencies that do not have the same kind of caps on damages. And so the claim under a particular state law, if it's uncapped, there is no such cap, the plaintiff or the plaintiff's lawyer will very often make the decision not to pursue a federal claim because the person can recover more money through the state court system. Also, I do think I should mention that I was an appointee of President Bush's and did serve in this administration. I was delighted to hear that Wade, at least with his criticisms of the administration, didn't cite the EEOC, because I'm quite proud of the work that I did there and that all of my colleagues did. And I will say that despite the trend that Dean Schwab identifies, the EEOC continues to have tremendous success in the federal courts. And during the 3 years that ended when I was general counsel, the Commission recovered $420 million through its litigation program, which was the highest ever in the Commission's history, both for a single year and for any 3-year period. And I can only say that I received the enthusiastic support to have and continue EEOC's tradition of aggressive civil rights enforcement and litigation from every member of the Bush administration with whom I served. A couple other things I'll mention, then I'll turn it over. With regard to success rates that Dean Schwab's study has found, I think it's important to give some thought to the mindset of a defendant in an employment discrimination case. And I can say and tell you that now that I'm back in private practice and defending cases, that one of the things that we always do, as did I think the independent lawyer that Cyrus cited in the study, we always assess the merits of the case, either a threatened case if we receive a lawyer. If Cyrus sends me a lawyer and says, I'm about to sue your client, do you want to talk about settling it? We always size up the case as outside counsel and advise the employer that there may be an opportunity to settle the case early on, either through EEOC's mediation program or through interaction with the lawyer for the plaintiff. If we determine that the case has merit, that unlawful discrimination occurred, that the employer is likely to lose, we very often recommend settlement early. We recommend that the employer avoid the cost, the adverse publicity, and the agony that it will go through as well as a plaintiff will go through, and settle the case early on. And I think that settlement data may not be captured in Dean Schwab's study, although I would defer to him on precisely what's in there and what isn't. But certainly things that are settled short of litigation, as a practical matter, are settled privately and without any kind of statistical measure. And finally, I will say one other thing about the Supreme Court of the United States, and this is something Cyrus and I talked about, is that we have not seen the trend in the Supreme Court of the United States that Dean Schwab's study identifies. It is certainly true that, as in the case of Lilly Ledbetter versus Goodyear, that there are times when employees have lost in the Supreme Court recently. But on the other hand, there have been a series of decisions, including several decisions this past term, in which the Supreme Court of the United States has ruled against employers and has ruled in favor of employees. And I'll mention just one case, a case called Seabox versus Humphreys. And in that case, Mr. Humphreys worked for a Cracker Barrel restaurant. He objected to race discrimination in the workplace. He was fired shortly thereafter, and he brought a claim under a Civil Rights Act of 1866, a Civil War era statute. And the case went all the way up to the Supreme Court of the United States. And the question was whether or not, despite the fact that the language of the law did not include an anti-retaliation protection, whether or not that kind of protection was implied. And the Supreme Court did say by a 7-2 majority with that, in fact, that the law does recognize retaliation, and it ruled in favor of Mr. Humphreys. There are several other cases that one could cite, but I just wanted to mention that. And I don't know if Dean Schwab would take issue with that. I know his study is focused on the lower courts, but there are many cases, at least in the Supreme Court, where we do not see the same kind of trend. The Ledbetter case obviously being an exception to that.
Very good. Now, Dean, do you have a response? Can you enlighten us on that issue?
I just want to say a couple things, very, very quickly. I don't want to get into technicalities. But your direct question on are settlements included in the data? Our data set starts with the case has to be. Well, what we study is cases terminated in the federal courts. And, of course, to be terminated in the federal courts, you have to get into the federal courts, so it has to be a complaint filed. So settlements before filing will not be in there. Settlements that are done after a case is filed will be part of our database. I didn't highlight it here today because I was focusing on the trials, but we do have some of our displays in the report on settlement rates, adjudication rates, and win rates on summary judgment. We don't study the Supreme Court as part of the study, so I'll let others comment on the Supreme Court cases.
Yes, Mr. Henderson.
Thanks, Judge. Let me reiterate something which was, I hope, implicit in my introduction, but let me make it explicit now, which is that the Leadership Conference is a nonpartisan, nonprofit organization. I represent the Leadership Conference. ACS is a nonpartisan, nonprofit organization, and we are not here to advocate on behalf of either or any candidate in any election. But having said that, elections matter. Elections matter. And this presidential election will determine, among other things, the future of the federal courts, perhaps for a generation to come. It is quite likely that there will be vacancies at the Supreme Court. But certainly there are existing vacancies, and likely to be more, at the courts of appeals, which are largely the body that decides most of the cases that affect the rights of ordinary persons under our Constitution. And I think we've heard of many examples for that. I just want to respond to the question of the occasional positive decision by the court, and whether it's in employment area or in other areas of its jurisprudence, all of which is true. And yet yesterday, the House of Representatives completed a process of overturning 4 or 5 Supreme Court decisions in the area of disabilities rights, reasserting the original congressional intent with respect to the protection of persons with disabilities in the workplace by overturning several decisions and passing the Americans with Disabilities Restoration Act. It was a unanimous vote in both houses of Congress, which belies the difficulty in working out acceptable language, but which reinforces the fact that there was a clear perspective on the part of Congress that the courts got it wrong in interpreting what Congress intended with respect to persons with disabilities. Congress is also debating the question of overturning the Ledbetter decision. There is a bill to do that. It has already passed the House of Representatives and has 57 votes in the Senate, more than a majority, but not enough to overturn a filibuster where 60 is needed. There are other bills now pending that would overturn a variety of additional Supreme Court decisions, most notably the Civil Rights Act of 2009, which is likely to be introduced immediately after the election, regardless of which presidential candidate is selected, that will address a number of decisions by the courts over the past decade. Fundamental questions that interpret, for example, things like whether the regulations that enforce Title VI against racial discrimination, ethnic discrimination, can be enforced by private parties. It goes beyond the employment area. But the point that I'm making is this. The court has proven, I think, over time to be less than friendly in a variety of areas. The employment area, and I think Dean Schwab's findings, really raise profound questions about whether in the normal course of things, the gap between these employment decisions and the way in which they've been handled and other areas of the law could have occurred as a natural consequence of the way decisions are made if there had not also been a predisposition, an ideological predisposition to address these cases. And lastly, the EEOC. I celebrate the work of the EEOC. It does the best it can as an agency that is hobbled by inadequate funding. But in the final analysis, it is the private bar that ultimately serves as the primary vindicator of the plaintiff's rights in employment discrimination cases. It is the private bar that drives the kind of compliance that occurs over time voluntarily by employers who fear the potential of litigation and therefore want to do the right thing. You never encourage that kind of collective attitude unless you have a vigorous private bar defending these cases in a court that is prepared to give them the fairness that they deserve. And that's essentially what this study helps to highlight and why it's so important.
Yes, the question here.
Let me ask you if folks have questions. We have people who will bring you a microphone. If you could identify yourself, wait for the mic, and then identify yourself. And
Hi, my name is Kim Atkins. I'm a reporter for Lawyers USA. Could any or all of the panelists speak to, in terms of the discrepancy between employment discrimination cases and other litigation cases, what factor the legal landscape, the burden shifting scheme that is involved in employment cases might have on this difference, and whether that has an inherent, that presents an inherent difficulty on plaintiffs both at the trial level and at the appellate level?
Are you referring to kind of the McDonnell-Douglas feat and having to deal with the pretext issue? Well, one thing is the Supreme Court overruled the Fourth Circuit on the Reeves case, saying that you can't do pretext plus. And so in theory, the Supreme Court has come out in a way that would allow the burden not to be as great as some of these court of appeals would like it to be. But it's still, we see there's enough room, I think, for these Court of Appeals who are predisposed in a hostile way against workers to come out against the employees and affirm summary judgments when they shouldn't, or to, overall come out in ways that disadvantage the employees.
If I could follow up on Cyrus's comments about that, and to some extent on Wade's. In the late 1980s, the Supreme Court decided a series of cases about the burdens of proof, particularly in the area of what's called disparate impact discrimination. That is, when an employer has a policy that is neutral, that looks neutral, but has an adverse impact on a group of people because of their race or their sex. And Congress didn't like that decision, and in the 1991 Civil Rights Act responded specifically and embodied in the language of Title VII the precise burdens of proof that apply in those kinds of cases. And I think that I think it's a terrific thing when as we do live in a democracy, for the Congress of the United States to scrutinize Supreme Court decisions and make an assessment about whether the Court's decisions either do agree with the original intention Congress had when it enacted an anti-discrimination protection, and this would apply in other areas as well. And if it doesn't agree, that Congress should look at that, and that certainly it's supreme in that area. And to the extent that Congress may disagree with burdens of proof or anything else, it certainly can and should take action to correct that.
Any other questions? Yes, I see your hand up here.
Hi, this is Debbie Vagans from the ACLU. This is a question for Dean Schwab. I'm wondering if you have any plans for a future study or have any predictions about the impact that the Ledbetter case will have on the number of claims that are being filed, considering that it constructively closes the window on the time period to file charges.
Again, hard to predict the future, either in what's going to happen out there or what I and my co-authors are going to write about. But that being said, yeah, I think this, we do plan on doing it. Again, our data set, which let me just come back to quickly, it has advantages and disadvantages. The advantages is we aren't studying a sample, random or otherwise. We're studying every single case, and that's the big advantage. I mean, we know every single case. The disadvantage is, because it's so large, we can't dig into the particulars of any case, and that's why, when Cyrus and others are describing particular cases and was this reversed because of a problem with the McDonnell-Douglas approach or something, our data set doesn't let us know. And so similarly, we won't be able to say whether it was the Ledbetter case or Lehman Brothers going under or a variety of other things, but we will be able to track over time. And for now, you can make the same predictions that I can. Will the number of cases continue to fall or go back up? Will the win rates stay where they are or go up, and the appeal and the reversal rates? And I think it's something that this data set is just super at monitoring over time, and we certainly plan on doing that.
Yes, here's a question.
I'm Mark Sheff from Workforce Management Magazine. Judge Jones had mentioned the Reagan administration as being one of the causes of the outcomes here. The judges President Reagan appointed, the cause of the outcome in the decisions in the federal court, and then Mr. Henderson mentioned George W. Bush's appointments as another reason. But in the middle, you had 8 years of President Clinton, and you said elections matter. Those two elections mattered. How many of the federal judges are his appointees, and why didn't that have an ameliorative effect?
Do you want to? Well, yeah, let me take a first crack at it, and then invite any and all to chime in. I do not have with me the statistics on the appointment of Clinton judges. I wish I did. You are correct. During the 8 years of President Clinton, approximately a third, I suspect, of the judiciary would have been appointed by President Clinton. There are obviously disputes, and you hear them frequently, between the political parties about which party appointed more judges than the other and which party impeded the appointment of judges more than others. So you hear that frequently. The evidence does, however, tend to suggest a couple of things. President Reagan certainly had a view about judicial appointments that did help politicize the courts in very dramatic ways, and I think it culminated in part with the dispute over the appointment of Robert Bork to the Supreme Court. That, of course, helped to create its own dynamic of partisan judicial review and appointment. But I will say that this president and this administration embodied a more highly politicized appointment process than his predecessors, either Bush 1, President Clinton, or President Reagan. This was a more ideologically driven appointment, and I point to the fact that the first 14 nominees that the president brought forth about 5 months after his appointment had a dramatic and ideological cast in terms of what each of them would have brought to the federal court in a sharpened way that highlighted, in my view at least, the ideological underpinnings of the appointment process. Now, I will say that President Clinton, in an effort to, and some will dispute this, but in an effort to achieve a level of balance in his appointment process, was certainly not known for appointing ideologically liberal judges in every respect. Some people will cite the Ginsburg appointment as an example of someone that refutes that. But if you look at the lower court appointments, the level of balance and equanimity in what he did in appointing people to the court belies the degree to which the ideological element of the current appointments have moved these courts dramatically to the right. And as I have said, in some instances where you have, obviously you can't look at every judge and assume that I am speaking about every judicial appointment. But I think in the aggregate it is fair to say that there was a clear cast in the way in which that was done. And I cited the Pickering appointment in specific terms because this was an example of a president hell-bent on getting a jurist appointed to the Court of Appeals, and I'm talking about sacred ground where it comes to civil rights decisions. There is no circuit that represents a poorer clientele than the Fifth Circuit with both blacks and Latinos, no circuit that represents poor women more than the Fifth Circuit Court of Appeals, so the issue of choice and poverty comes into play in the Fifth Circuit in ways that it doesn't in others. And to appoint a judge who had such a blatant hostility to employment cases, even with the record that I quoted to you, says that, fairness was tossed out of the window for purposes of achieving a political ideological point. And so that's really my position on it.
I would add an observation or two. When I left the court after serving 24 years, one of the byproducts of my leaving, or a bonus, was that I regained my First Amendment rights. And I am now therefore free to speak in ways I could not speak while serving as a sitting judge. So I can, and I do, pull the curtains back from time to time and share with professional groups and with anyone who has an interest what happens and what happened during the period of time that I was on the court. For instance, we're discussing what happens in courts of appeals. When a case goes to the Court of Appeals from a district court or from trial court for review, the first thing that the court has to look at is, given the issue presented, what is the standard of review that must guide the way in which the trial was conducted and the case is postured. And the standard of review permits the court to engage in a certain process. For instance, in examining the record of a trial, the court looks at the evidence to determine whether the claims on appeal are meritorious. Are the claims of error well founded? If they are errors, are they clearly erroneous? If clearly erroneous, they're subject to being reversed. If they are harmless errors, the Court of Appeal ignores them. Say, well, yeah, the judge, he or she did get this wrong, but it was harmless. In the areas of civil rights law and in employment cases, when on appeal, when you look at the various issues and the evidence that is in contention, it's if a judge's assessment as to whether that evidence was clearly erroneous or harmless error is determined largely by a judge's own background, the perspective, life experiences, and has been mentioned here that many cases that don't go all the way to conclusion in the trial are taken away from the jury under summary judgment. And the standard for a court exercising its power under with regard to ruling on a case with regard to summary judgment is whether the issue represents a genuine issue of material fact. Is what is in dispute a genuine issue of material fact? Now, what is genuine? That's often in the eye of the beholder. That's in the eye of the judge. Is it material? Material is in the eye of the judge. It depends upon how a judge views things. If a judge comes on with an ideological bent, if a judge doesn't believe that calling a woman out of her name is material, then it's going to be harmless error if that's a point of contention. If a judge doesn't feel that have posting signs on a person's locker with reference to the Ku Klux Klan is a basis for one concluding that there's a hostile work environment, well, that's harmless error. If an employer has been told that his supervisors are calling black employees boy, oh, that's nothing. That's harmless error. But that depends upon the judge, and many of these cases turn on how a judge at the appellate level brings to bear his or her life experiences in determining whether a claim is harmless or clear error. And when this is repeated over and over again, this has an effect upon the willingness of persons to continue to rely upon federal courts in bringing their cases. Another bit of intelligence I'll share with you is what happens in court conferences. When I testified, I'll tell you this, I testified at the Judicial Confirmation hearing of now Chief Justice Roberts. I did it very reluctantly. When I was first asked to do it, I declined. But then when I got inquiries and requests from the staffs of Senator Leahy and Senator Kennedy, I agreed to do it. And the reason I testified was to provide a context for considering the nomination. The press focus had been on the brilliance of Judge Roberts at that time. Not in dispute. Brilliant lawyer, very experienced, Harvard, had been in the Reagan White House, had been in the counsel's office, had been in the Justice Department. Technically, intellectually, unassailable qualifications. But I took the position and I said to the committee that when you are examining the fitness of one to be the Chief Justice of the United States, you go beyond those qualifications and you look at other things. You look at values. You look at whether the nominee has a sensitivity to issues that go beyond whether one writes a brilliant opinion or wrote a brilliant law review note. It was in the record before that committee that Judge Roberts had authored a number of memoranda while in the White House and in the Justice Department dealing with civil rights issues. And those memoranda surfaced or were drafted about the same time as I was serving on the Court of Appeals, and I was curious about the constant assault upon remedial principles which I thought, and many lawyers thought, and judges thought had been settled with regard to affirmative action, school desegregation. But cases continue to come up to our court. In particular, there was a case from Memphis, the Stotts case, in which the city of Memphis had been sued for discriminating against blacks in the hiring of in the police department and promotions, and also in the fire department. The city did not want the dirty linen aired, so it entered a consent decree with the Justice Department and the plaintiffs. And a plan was in effect. It was working. The department became quite diverse all along the line, in all the ranks. And so in the mid-'80s, there's a challenge filed to the consent decree. The district judge who had presided over the litigation and had approved the consent decree denied the challenges to the consent decree, and they came up to the Sixth Circuit. I was on the panel that considered the first appeal, and we affirmed the district judge in his denial and dismissal of the attack on the consent decree. A motion was filed for rehearing en banc. And by that time, there had been a sufficient number of new judges added to the Sixth Circuit by President Reagan that changed the balance of the court. And under the rules, when a petition or a motion for rehearing en banc is filed, it is considered by all active judges. And if a majority of the judges in active service vote to rehear or to hear a case that had been determined by a panel, then that panel opinion is set aside, and the case is scheduled to be heard by the en banc court, the full court. And when we were in conference on that case, I was astounded by comments that were made by judges with regard to the appropriateness of the reasoning, the appropriateness of affirmative action, the appropriateness of the consent decree. And we saw this thing repeated over and over again in other cases, and I couldn't figure out what's prompting this wave of attacks upon settled principles of law and remedies. Well, when Judge Roberts was under consideration for appointment to the Supreme Court as Chief Justice, some memos surfaced from the Hoover Institute and other places that suggested or that showed that while in the White House and the Justice Department, he was the author of a number of the opinions, that were the source of a lot of the attacks upon these consent decrees and affirmative action. And I was pointing out to the committee that they needed to explore this and find out whether in drafting these opinions and drafting these memoranda, whether he was reflecting the opinion of his client. If so, a lawyer may do that. There's no argument there. But if these were personal opinions, if these reflected his feelings, then I felt the Judicial Committee had a real problem and should explore more deeply the fitness to be Chief Justice of the United States. I'm pointing this out to indicate that this assault upon civil rights remedies that has led to the decline in the federal cases, the civil rights cases, employment cases, was by design. This was a strategy. It wasn't accidental. And therefore, the machinery of justice is in the hands today of persons who are unsympathetic to civil rights litigation and moving forward to correct societal injustices through the law. And consequently, unless we understand the historical connection between the political, the judicial nominating process, and the issues we face now that reflect what we see now in this study, we'll just be repeating this situation and perpetuating it. Ms. Applebaum, I assume that I told you I thought I would make a comment. If that's my closing argument, so be it, and you may take it. And
the quality of this conversation has been so great that I hate to be the one to cut it off, but we promised everyone we would end at 2. So, sorry. Now? I regret to cut off this great conversation that our panelists are having. I hope it's been enlightening for everyone. We promised you we would end at 2, and so I'm going to ask you all to join me in thanking our great panel, and thank you for coming.
Wow. Judge Jones really did. Stuart, thank you.